Good morning. The court will go on the record. Today is February 12th, 2025. The first matter on the court's docket is Megan Carpenter versus Stephen Hamblin, file number 10-13750DS. Do you have anybody present on that? Either party is present. They need to unmute and identify themselves for the record.
I'm here, Megan.
Okay, it's Megan Ritchie now.
Yes.
All right. Part of the court, what is the status of this matter?
The defendant has a support obligation of $289 and a balance of $2,613.72. The last payment was received in the amount of $158.07 in July of 2024 from a prior income withholding. There's been no contact with the defendant. The front of the court doesn't have a valid phone number as well for him.
Thank you. Ms. Ritchie, any questions or anything that you would like to say?
Nope.
Given the failure to appear, I will recommend a bench warrant. I'll recommend a bench warrant in the amount of $1,000 plus $100 in costs. Any questions, Ms. Ritchie?
No.
All right. Thank you for appearing. You can sign off.
All right. Thank you.
For next call, the matter of Alicia Ballinger versus Gerald Ballinger, file number 12-14526DM. Do you have anyone present on that matter?
Yes, sir. Mr. Gerald Ballinger here.
Thank you. In front of the court, what is the status of this file?
On December 10th, 2024, the court issued a bench warrant for the defendant after he failed to appear for a show cause hearing. The defendant had contact with a friend of the court and provided medical documentation of his inability to earn income since February of 2024. A stipulated order was drafted and presented to the court for consideration. The court entered the order, which required the defendant to appear today and supply proof of his application for disability, which has been provided. The defendant's support obligation is $335 and a balance of $4,663.55.
Thank you. Mr. Ballinger, anything that you would like to say?
Well, I had a brain aneurysm and I haven't been able to work, so I'm just waiting on Social Security. I have a meeting with to see about my back for Social Security on March the 9th, and then that should cover everything that they need, and I should get a decision after that.
Okay. When this happened back in February, did you contact the front of the court at all, let them know what was going on?
No, I never did that, sir. That's why this happened.
All right. So what I'm going to do is adjourn your matter out a little bit of time to allow to see that status of that disability claim. It's somewhat a slow process, so I'm going to set you out a few months. I'm actually going to put you out to May 14th.
Okay.
But if there's any updates, you got to make sure you let your caseworker know. I do think it's appropriate to abate support. I'm going to review your file and then we'll determine what day we'll abate that to. But I think given the information, I did review that medical records, that would be appropriate. Any questions, sir?
No, sir.
All right. Well, I'll see you back here May 14th. Like I said, make sure you stay in touch with your caseworker if there's any new updates. Okay.
Okay.
Thank you. You're all set.
Thank you.
Our next call is a matter of Lindsay Bucco versus Joshua Higley, file number 17-16932DS. Do you have anyone present on that matter?
I am, Your Honor.
Good morning, Mr. Higley. Front of the court, what is the status of this matter?
The defendant had failed to comply with terms of the stipulated order date November 1st of 2024, that the defendant would pay $216 monthly. This sum was composed of current support obligation of $166 and $50 for due support commencing on December 1st. No payment was received in December, but the defendant did meet the stipulation amount in January. The defendant made a $100 payment yesterday with a specific payment voucher that's still pending. He also indicated he has a plan to meet his obligation for February and the missed amounts from December by the end of this month.
And what is that total again?
The remainder would be including December's of the 216 plus an additional $116 for the remainder of this month.
Thank you. Mr. Higley, what would you like to say?
She is correct, and I do plan on making December's payment also before the end of the month. I had some other cases that came up in December that kind of set me back a little farther than expected, especially with the holidays.
You think you can get that 316 in by the February 24th?
Oh yeah, no problem.
All right. So I'm going to indicate then that you're to pay 316 by February 20, close the business on February 24th. We're going to reset you for March 19th just to make sure that that's happened and also to see where we're at moving forward. Okay?
All right.
All right. Thank you.
Thank you.
Next call is the matter of Abigail Hornstra versus Nicholas Foose, file number 22-18992 DP. Do you have anyone present on that matter?
I'm here, Your Honor.
Good morning. We do have Ms. Hornstra present. Front of the court, what is the status of this matter?
The defendant's obligation is $153 and a balance of $5,284.61. Last payment was received in June of 2024 in the amount of $37.59. The defendant has not complied with the support order from October 21st of 2024. It does appear, though, that the defendant served the sentence, but was additionally ordered to contact a friend of the court upon release. There's been no contact or payment. The friend of the court would request to adjourn to the judge to address non-compliance with the order.
And at this time, then this matter would go to Judge Hesselink.
Correct.
Ms. Hornstra, any questions or any comments that you would like to make?
All I know about Mr. Fust is that he's currently in some more legal trouble downstate. So he doesn't really seem to care about appearing for friend of the court.
All right, what we're going to do then is set the matter before the judge to address his behavior in this matter. We'll adjourn this matter to March 14th before Judge Hesselink. Thank you for appearing, ma'am. You are all set.
Thank you.
All right, it is 9:30. The court will go back on the record and call the matter of April Hall versus Johnny Wiggs, file number 98-7823DM. Anyone present on that matter? Not appear that either party is present. In front of the court, what is the status of this matter?
Your Honor, the defendant was arrested on January 10th, and we did a stip where he was going to pay $200 before today and then also be present today. It's an arrears only case with a balance of $95,920.74. The last payment we received was in September of 21 in the amount of $444.89. During our break from the last hearing, I did speak with Mr. Wiggs, and he thought he had everything figured out with Zoom, so I'm a little bit surprised that he's not present.
All right, I'll pass the matter then and let him get hopefully signed in. We'll call the matter of Catherine Wenner versus Jonathan Wenner, file number 05-11378DM. Do you have anyone present on that matter? Not appear that either party is present. In front of the court, what is the status of this matter?
The defendant was arrested on December 30th, and we did a stip order with him where he was going to supply a doctor's note and appear today. He has not done either. He was aware of this hearing as he did miss the previous one on January 15th. And we discussed the importance of being here. This is also an arrears only case. Balance on this is $19,306.34. Last payment received was in January of 2019 in the amount of $150.
When was that payment?
The last payment received was $150 in January of 19.
Okay. All right, given the failure to appear as well as to comply with those terms, I will recommend a bench warrant of $5,500 plus $100 in costs. We're next call a matter of Alicia Payton versus Sean Van Horn. Number 08-12717DS. Do we have anyone present on that file? It's not appear that either party is present. In front of the court, what is the status of this matter?
This matter was adjourned from January 15th. The defendant has an arrears only case with an ordered on arrears of $73. Total balance is $2,857.75. There is an active income withholding, however, it has not told enough to be applied to this arrears only case. It did apply to his other two cases that you're hearing today. The last payment we have received for this specific docket was back in March of 24 in the amount of $126.65.
Given that there is an active withholding order, I'm going to adjourn this as well as other matters. Just a short adjournment to March 19th to make sure that that is still collecting and see where we're at. Also, the next call the matter of Nicole Garcia versus Sean Van Horn, 09-13045DS. Do we have anyone present on that? Not appear that either party is present. So this matter is getting some money through income withholding order. Is that correct?
That is correct. We have received $193.58. His support obligation is $294, with $50 ordered on arrears. And the current balance on his account as of today is $4,413.58.
All right, I will adjourn this matter to March 19th again to monitor that collection on income withholding order. For the next call, the matter of Robert Martin versus Angela Phelan. Number 11-14165DS. Do we have anyone present on this matter? Does everyone have anyone present? In front of the court, what is the status of this file?
The plaintiff has a support obligation of $166 a month, and the current balance on his account is $1,036. Last payment received was in September of 24 in the amount of $200. Since then, I've tried numerous times to get in contact with him. I've left several voicemails, and he has yet to make any kind of payments or make any contact with me.
Given the failure to appear, I will recommend a bench warrant amount of $500 plus $100 costs. We're next call a matter of Alicia Westcott versus Gabriel Schumann, file number 12-14500DS. Do we have anyone present on that matter? So not either party is present. From the court, what is the status of this file?
The defendant has a monthly support obligation of $754 and a current balance on his account of $12,376.94. He last paid in January in the amount of $70. He satisfied his obligation in December and November, but prior to that, we were receiving very minimal payments, not even meeting half of the obligation.
Any contact with him?
No contact with him.
Given the failure to appear as well as the very large arrears in this matter, I will recommend a bench warrant amount of $3,100 plus $100 in costs. Next call is the matter of Brian Sullivan versus Alice Winslow, file number 14-15515DM. If anyone present on that matter. It's not clear that either party is present. In front of the court, what is the status of this matter?
The defendant was last here on December 9th, and we adjourned the matter to today to monitor payments for both December and January. Her monthly support obligation is $15, and the current balance on the account is $465.03. Last payment received was in November in the amount of $15. On December 3rd, I did speak with Ms. Winslow, and she informed me that she did lose her job at McDonald's. No further contact since that time.
Given the failure to appear, I will recommend the bench warrant amount of $500 plus $100 in costs. Matter of Sandra McDonald versus Timothy Roper, file number 15-16136DP. Do you have anyone present on that matter?
Yes.
All right, we do have Mr. Roper present. In front of the court, what is the status of this matter?
The defendant has a monthly obligation of $352 plus $50 ordered on arrears. Current balance is $9,864.53. Last payment received was this month in the amount of $75. January, we received $150, and in November, we received $50.
Thank you. Mr. Roper, what would you like to say?
I was just started a new business I'm trying to do now, so I've been trying to pay what I can.
All right. Well, are you anticipating getting some more payments in and starting to meet this obligation?
Yes.
All right. I'm going to hold you to that. I'm going to adjourn you to go to April 16th. So that will give you the rest of this month as well as March and half of April to show that you can make an effort on your payments here and get yourself back on track and start to address getting caught up. Any questions, sir?
No, sir.
All right, we'll see you back here on April 16th with the expectation that you'll have made some sizable payments by that time. You're all set and can sign off.
All right. Thanks.
Next call, the matter of Hannah Johnson versus Levi Wilson, file number 16-16578DS. Do we have anyone present on that file? I appear that either party is present. In front of the court, what is the status of this matter?
This matter was adjourned from January 15th due to the defendant's failure to appear. He has a monthly support obligation of $364 with $50 ordered on arrears. Current balance is $9,199.89. We have been receiving partial payments for both, well, since December. Last month we received $124.02, and then this month we received $124.02. I think considering we have an income withholding order, maybe we adjourn it one more time just to see if it's able to satisfy that.
All right, I will give that opportunity, given that there is the active withholding order. We'll adjourn the matter to March 19th. Next call, matter of Katrina Thompson versus David Thompson, file number 17-16811UM. If anyone present on that matter, it does not appear that either party is present. In front of the court, what is the status of this file?
The defendant has an arrears only obligation with a current balance of $14,854.05. He had been arrested on his warrant and posted bond. That is the last payment we received in December of 24. Prior to that, we received another bond payment in June of 24.
Given the failure to appear, I will recommend a bench warrant. In this matter, I'm going to recommend a bench warrant in the amount of $6,000 plus $100 in costs. For the record on this matter was set for 9:30. It's now 9:42. For next call, the matter of Megan Van Horn versus Sean Van Horn. file number 17-16848DM. Do we have anyone present on this matter? Either party is present. We can call other matters for Mr. Van Horn. I know there is an active withholding order, so my intent would be to adjourn this matter to the other dates, which I believe was March 19th. Turn this matter to March 19th. Next, call the matter of Deborah Taylor versus James Mercer, file 17-16912 DP. Anyone present on that matter? It's not appear that either party is present. In front of the court, what is the status of this file?
This matter was adjourned December 11th to monitor the income withholding order for the defendant. He had been arrested on August 24, in August of 24, and we did a step where he had agreed to pay $50 a month. He has been doing that consistently since December. No payment yet for February. Current balance is $3,773.47.
Any recommendation? Would you like to monitor this one more time, or you
I
recommend?
think I would like to monitor it one more time.
We'll adjourn then to, we'll just go to March 12th just to make sure that February payment is processed. The next call, the matter of Ashley Fisher versus Jody Mogenberg, file number 18-17144DS. Do anyone present on that file? Does not appear that either party is present. In front of the court, what is the status of this matter?
This matter was adjourned from December 11th to allow time for the income withholding order to be established. She has a monthly support obligation of $272 and a balance of $1,807.02. It does appear Ms. Fisher has an income withholding order that's established. We did meet the obligation last month, and we have received one payment so far this month. I don't know if it would be appropriate to adjourn it one more time just to make sure everything's going okay.
I think it would be, make sense to adjourn the monitor. We'll adjourn this one out to April 16th. We're going to call the matter of Heather Green versus Michael Zadney, file number 18-17519DM. Do you have any present on that matter?
Heather Green is here.
Michael
Thank you.
Zadney here.
All right, we have both parties present. In front of the court, what is the status of this matter?
This matter was adjourned from December 11th to allow the defendant time to tend to his criminal matters, and then to file any motions that he wanted to potentially modify any orders. He has a support obligation of $1,040 plus $50 ordered on arrears, and a current balance of $41,309. Last payment received was in January of 25, the amount of $76.59. Prior to that, it was in September, in the amount of $525.75. I did speak with the defendant on February 6th, where he reported a new employer. Therefore, I think it may be appropriate to adjourn just to monitor payment.
Mr. Zadney, what would you like to say?
That I did get a new job, and as soon as I get my first check, I will have money into the court.
All right, when did you start that job?
I just started as of 2 days ago. I just got out here.
Okay. Is that full-time employment?
Yep.
And in front of the court, you had that information for that job?
Yes, sir.
All right. Ms. Green, any questions or any comments that you would like to make?
No, I don't really have anything to say about it.
Thank you. All right, so given the report of a new job, I will adjourn the matter just to monitor and make sure payments are being made. Obviously, sir, you've got a very steep hill to climb. So the court is going to expect that you're making your payments. And we'll also have to start addressing how we're going to deal with the amount that is owed. But I will give the opportunity to make sure that this income withholding order is in place. You are ordered, though, until that withholding order is in place and money comes out of your check, you need to make payments directly. Do you understand that?
Yes, sir.
All right. It can't be, well, I'm going to wait till it starts coming out by the court. It's going to be, you're working, you need to make payments so we're not falling further behind. I'm going to adjourn your matter to March 19th so we can follow up on that income withholding order and make sure you're making direct payments until that is in place. Any questions, sir?
Nope.
All right. Thank you both for appearing. You may sign off.
All right, thank you.
I must have did something wrong or something. Not in the waiting room or something. Enable reading room.
Z. Miller versus Vinzenz Waney, file number 18-17520DP. Do you have anyone present on that matter?
Yes, sir, Mr. Waney, I'm here.
All right, thank you. In front of the court, what is the status of this matter?
The defendant has a support obligation of $229 plus $50 ordered on arrears. The current balance is $9,337.06. Last payment received was in October of 24 in the amount of $500. He was also found in contempt previously in December of 2023.
All right, Mr. Waney, what would you like to say?
Well, since the beginning of December, I was laid off with my job. I work for a company called Future Hybrid Home Builder based out of Mackinac City. Like I say, at the beginning of December, I was laid off, and since then I've been seeking other employment. It's kind of difficult given my record. Not a lot of people want to hire a sex offender. But I have had a break recently, and tomorrow I'm supposed to be starting a cash job.
Okay. So it sounds like you were working for a while at that last job. Is that correct?
Yes, sir. Yeah, I was doing very well at that last job. It's just like I said, because of the winter time, I was laid off.
How long did you have that job?
About 6 months.
Okay. And you're laid off, so are you going to go back when the winter's over?
Yes, sir. As soon as they have more work for me.
Were you making regular payments while you were working? Because it doesn't look like it.
I was making payments at the earliest convenience whenever I was able to afford it. I also have some other fines and costs that I have been trying to pay on as a result of the CSC case, and I have another case as well. But I'm not just trying to ignore my responsibilities. I do understand the seriousness of this situation.
Based on the history, it doesn't look like you made a very good effort last year. You're approaching $10,000, so we're not going to let that continue to grow. I'm going to adjourn you out, given that you said you've got a potential opportunity to get some payments in. I'm going to set you over to March 19th with the expectation that you're finding some employment and getting a payment in, and then we'll discuss the future moving forward, okay?
Yes, sir. Thank you.
You're all set. You can sign off. We're next call the matter of Sabrina Ball versus Alan Sevarns, file number 19-17728DP. Do you have anyone present on that matter? It's not clear that either party is present. In front of the court, what is the status of this file?
The defendant has a monthly obligation of $417 and a current balance on his account of $4,806.24. The last payment received was in October of 24 in the amount of $119.89. Also, you should note that in October of 24, we did an ex parte to recall his bench warrant as regular payments had been coming in. However, it seems once we did that, the payments stopped. I have not had any contact with Mr. Sevarns, and we do have some return mail for him.
Failure to appear, I will recommend the bench warrant amount of $1,500 plus $100 in costs. The next call a matter of Kenda Poma versus Michael Poma, file number 22-18820DM. Anyone present on that matter? You see a Michael Poma listed, so if you are present, you need to unmute on and recall that matter to see if Mr. Poma is actually present and can unmute. Court would then call the matter of Shannon Susi versus Kayla Stantz, file number 23-19380DM. Do you have anyone present on that?
Kayla Stantz is here.
Good morning. So we have Mr. Susi present also. I saw your mouth move, sir, but you're muted, so I couldn't hear you.
I'm sorry, Your Honor. I'm here now.
All right, Mr. Palma, you're going to need to hold on because I called another case, okay? And then Mr. Susi, can you hear me okay?
Yes, sir. Yeah. Yep. Hear me?
Thank you. From the court, what is the status of this matter?
This matter was adjourned from December 11th to monitor the defendant's payments. She has a monthly support obligation of $48 and a current balance of $469. Last payment received was in December in the amount of $200. Prior to that, it was August in the amount of $50. We have not had any contact with her. However, today she did message one of our staff members through Zoom and gave us new contact information and a new mailing address that we would need her to provide on the record, as well as potential new job information.
Thank you. Ms. Stantz, what would you like to say?
Yes, I just started a new job. I should be getting my first check in 2 weeks. I do plan on making weekly payments so I can get this caught up as quickly as possible.
What is that job?
It's for Tony Sanitation. I am in charge of making sure all the routes get sent out to the drivers.
Okay. And do you have a new address or new mailing information?
Well, it's a new mailing address so that my mail can start going to my mother's house, so that any mail that comes in, I'm actually given the information.
All right, I would order the front of the court to update that. Could you provide that address, or do you want to provide that by phone?
I'll call in and give it to them.
All right. So make sure you do that. I would order the front of the court to update that. So,
yes.
Mr. Susi, anything that you would like to say on this matter?
Oh, Your Honor, there's nothing for me to say.
Okay. All right. Well, with the representation that there is employment, waiting on payment to start, I will adjourn this matter out. I'll go to April 16th so that we have time to get everything in place as far as any withholding order. And Ms. Stantz, you know, if there is no withholding order in place, Ms. Stantz, you do need to make sure you're making a payment. Okay.
Absolutely.
Your Honor.
Yes, sir.
Before you set that date, hold on 1 second. I have a pending court date. I have a pending court date that day.
All right. Well, I can go to April 23rd. Is that day okay for you, sir?
Let me verify that on the calendar. Yes, sir, it is.
All right. All right. So given that conflict with his schedule, we will adjourn it matter to April 23rd. And again, Ms. Stantz, just make sure you're getting those payments in if it isn't coming out, and hopefully everything will be squared away by then and we can move forward. Any questions, ma'am?
No.
All right. Thank you both for appearing. You're all set. You can sign off. All right. I'm going to go back to the Poma matter. So Kenda Poma versus Michael Poma, file 22-18820 DM. Mr. Poma, can you hear me okay?
Yes. Can you hear me, sir?
I can. Thank you. In front of the court, what is the status of this matter?
This matter was adjourned from January 15th to monitor the defendant's payments. He has a support obligation of $552 and a current balance of $6,656.27. Last payment received was in November in the amount of $250. I did speak with Mr. Poma on the 10th. He advised that he was still taking care of his ill father and therefore unable to pay.
All right, Mr. Poma, what would you like to say?
Your Honor, I'm a house painter, and it's really, there's not really no work yet, but my boss said we will be working soon, and I will get caught up again. That's all I got to say.
All right. Well, this balance continues to grow. There has not been a payment for a couple of months at all. So I am going to recommend a finding of contempt and that the matter be set before the judge. Recommend the matter be set for April 11th. In case you do get some payments. If you do make a payment of $2,000 prior to that court date before Judge Hesselink, then you would not have to appear. If you have not made that payment, you would need to appear. I do find that you are in arrears and that you have the capacity to make some type of payment on this matter, and you have not exercised due diligence in making a payment. So you'll get notice, sir, to appear before Judge Hesselink April 11th, but as indicated, if you do make a payment of $2,000 prior to that court date, you would not have to appear. Any questions, sir?
No, sir. Now that I'm sorry, what date would that be?
April 11th.
All right, and I do the same thing on the phone on April 11th.
Yes, you can be by Zoom, yes.
All right, Your Honor, thank you.
Thank you, you're all set. All right, the court will call the matter of April Hall versus Johnny Wiggs, file number 98-7823DM. Mr. Wiggs, if you could please unmute.
There you go, sir. Can you hear me, Your Honor?
I can, thank you. In front of the court, what is the status of this matter?
The defendant was arrested on January 10th of this year, and we did a stip with him where he was to pay $200 before today and then also appear today. It's an arrears only case with a current balance of $95,920.74. Last payment received was in September of 21 in the amount of $444.89.
Hey, Mr. Wiggs, what would you like to say?
I'd just like to say, Your Honor, that I have, this has been an ongoing thing for many years for me, as you can see. I was sentenced to prison over this case when my children were under 18. I have been bounced around. Miss Blaine helped me greatly a few weekends ago, but I went from there to Sheboygan for a arrears case as well, and I went to jail in Emmett for a fine. I hope I have work. I know that I made a step agreement for $200 a month, if not more, of course. And I know I can have that within a week. Like I said, I'm still looking for work. I got a little money, but like I said, I'm paying arrears in Sheboygan as well. And had a fine in Emmett County I had to take care of as well.
All right, so you paid nothing then after that agreement to pay the 200 here, is that correct?
Yeah, I asked about if I had time period. I tried to get it before the 12th, before today. And to no avail. I couldn't, it's not going to happen until, like I said, Your Honor, maybe a week. I can have the 200 for this month.
All right,
As I
I'll
said,
adjourn you to March. I'll adjourn you to March 12th. I'll adjourn you to March 12th. We're gonna hold you to that, getting in at least $200 prior to that court date.
Absolutely.
Obviously, you're a little bit more behind than that, so paying more would be more helpful, but we're gonna expect a minimum. When I see you back next year on March 12th, you'll have paid at least $200. Any questions, sir?
Thank you, Your Honor. Thank you, Your Honor.
All set.
Thank you.
The court next call the matter of Ashley Hofstra versus Kyle Wilson, file number 19-17865DS. We have the parties present on that matter.
Yes, Judge. Good morning. Elliot Blumberg on behalf of the plaintiff, Ashley Hofstra, who's appearing via Zoom from my office.
Thank you. Do we have Kyle Wilson present?
Can you hear me?
Are you Mr. Wilson? Yes, sir.
Yes, sorry, I was muted. Yes, I am present.
All right, thank you. So we do have both parties present. Looks like this is a referral from the judge.
Yeah, Your Honor, my client had filed on her own an ex parte emergency motion to change parenting time. That was denied by Judge Mertz and referred to you for the proceedings.
Okay. Are you requesting an evidentiary hearing at this time?
We are, Judge. I think the court should probably be mindful of the inconsistent documents that exist in this case. There is a September 2019 mediation agreement followed by a November 2019 court order that are inconsistent. And the reason that I bring that up now is that there are parenting time violations that are going to be heard by this court later this month, which I don't believe can properly proceed because the order of the court does not provide the parenting time that is being alleged to have been violated. So and I apologize for rambling somewhat, but I think when the court has an opportunity to review the court file, you'll see that there are inconsistent documents in place. But what we are asking for is an evidentiary hearing to have the parenting time modified.
Okay. Are you requesting a 3-hour spot or a 1 hour?
Are those the two choices?
Those are your two choices.
2 hours would probably be sufficient. I don't think we need 3. Is that even possible?
Potentially, I'll put you down for a 3-hour spot now, and then we'll make a note that maybe we can sneak another 1-hour case in there if we need to.
Okay.
Mr. Wilson, what would you like to say regarding this matter?
Considering that Ms. Hofstra has gained legal representation in this case, I might want to come back and re-adjourn with my own legal representation.
All right, so what I'm doing here is we're just going to set the matter for a hearing that will certainly give you time to secure counsel. I do see that we have a show cause also set in March, but so Mr. Blumberg, my next 3-hour is April 30th at 1 o'clock. Do you have any conflicts with that time?
I'm not sure I do, but I'll move anything. So I'm sorry, what was the date again? April what?
April 30th.
Yeah, that will be fine.
All right, so we'll set the matter for April 30th at 1 o'clock. The child
Is 6 years old. I don't think that I think your 7-year-old is usually your policy in regard to interviews.
7 is where I absolutely will talk to the child unless the parents feel I should talk to a child that is younger and can convince me that the child is appropriate for that type of discussion. So if parties want to make that argument, they can. If not, there would not be a preference interview. I would also say that we would address this pairing time issue on that date. So I know we have a date coming up, I think in March, or maybe even this month too, potentially.
There's 5 total pending.
Okay, so all of the show causes against Ms. Hofstra and any issues related to any pairing time violation will also be addressed at that hearing on the 30th. There's no need for the parties then to appear on those other dates for those show causes, because those will simply be addressed at that time, as well as any potential new pairing time violations that are filed.
If I were to file a motion to have those show causes dismissed, you would hear that on that April 30th date?
Yes.
Okay.
I'm also going to indicate that the parties do need to file any witness and exhibit lists if they intend to call any witnesses or submit any exhibits at least 14 days before the hearing date.
Exhibit being video and audio evidence as well, yes?
Yes, that would include that. So you need to provide a witness and exhibit list to counsel, file it with the court within 14 days, and the parties should exchange exhibits with each other. You do not need to provide them to the court ahead of time, just simply have them available for the hearing itself. Mr. Plumber, that's a new procedure, so make a note of that.
I'm writing it down. Thank you.
Mr. Wilson, any questions?
I suppose the only question I have is, I'll begin with a statement. I have missed 12 overnights with my daughter, and they have been consistent, and she being the mother of my child, has no plans on bringing her to me at all. And I'm just wondering, am I supposed to sit here idly by and continue to submit to the court these violations that she's committing weekend after weekend and just expect to not see my daughter at all? I'm just very confused at this whole situation and this meeting actually right now that we're in currently, all of us, and why I'm even subject to continue to come back to court when I am not the one in any violation at all. My daughter is being withheld from me on very baseless claims. I actually have the video evidence in question, a better version of it that Ms. Hofstra has. She has a very narrow scoped version of a video that puts me in a very specific light, which is illegal to present to court. I have a full spectrum video of very high definition audio evidence and video evidence from the full front perspective on exactly how what happened that night happened and who the real danger and threat in the situation is, which would be Mr. Matthew Sargent. My daughter was kept from me in a very tumultuous and dangerous situation, and she was kept in a home with a man who was threatening me.
Mr. Wilson, hold on. We're not arguing the case today. This is a status conference to kind of address where we're headed and where we get. And that's what we're doing, is setting the matter for the evidentiary hearing when we hear arguments from everyone. I can't give you legal advice. You could speak to an attorney about potential options that you have at this time if parenting time is being withheld against an order, but we'll certainly address all that also at the hearing. If somebody is withholding time wrongfully, the court has options, including makeup parenting time and other issues, but those are things we would address at that evidentiary hearing, okay?
Okay.
All right, so we'll see everybody back here April 30th. Again, those show causes would be addressed on that date. No need to appear for those.
Thank you.
Any questions, Mr. Plumber? Nope. All right, thank you both for appearing. You are all set and can sign off. We're next call the matter of Jacob Totten versus Virginia Totten, file number 24-19844DM. We have the parties on that matter present. Does not appear that the parties are present. Do see they have a final hearing before, well, before Judge Mertz on April 7th. What I would recommend is that we adjourn this matter to a date past that April 7th. They may resolve it that day in front of Judge Mertz, then it could come off. But if not, we'd address any issues we need to address at that time. We're next call the matter of Nicole Priestley versus David Duarte Bell, file number 24-19935DM. We have the parties on that matter present.
Yeah, I'm here. David Bell.
Thank you.
You're welcome.
I'm here too, Nicole Priestley.
All right, thank you. Both parties are present. This is a initial hearing to address custody, parenting time, and support. Ms. Priestley, you are the plaintiff, so I'll ask you first. Do the two of you have any agreements on those issues?
We have agreed to share everything.
Okay. It looks like you were in front of Judge Hunter perhaps last week.
Yes.
Did you guys put any agreement on the record at that time in front of Judge Hunter?
I believe we did a mutual agreement for, I don't know how specific it got. It was a very fast meeting. And that he requested that I turn in my judgment of divorce, which I did this morning.
All right, so you turned in a judgment of divorce to the clerk's office this morning?
Yes.
So in general, what did you guys agree to as far as custody?
50-50 physical, 50-50, what is the other
Legal?
one they call it?
Legal.
Yes, 50-50 joint for both parties.
Okay. And then how about parenting time?
We've agreed to do whatever verbally we come to a conclusion with.
Okay, so no set specific schedule, just as the two of you agree?
Yes, yes.
Okay. Does that include like holiday parenting time also?
Yes, it does.
Okay. Did the two of you address child support at all?
Well, we share everything financially with the children, so there's no concern there.
All right. Have you filed a motion to opt out of child support or friend of the court services?
I don't believe so. I wasn't sure if I needed, it can all be kind of confusing. So what did you say that was?
Motion to opt out of friend of the court services. Well, let me ask you about something. So you're not asking for child support?
No, no.
Okay. Mr. Duarte Bell, is that accurate?
Yes, sir.
Okay. So what I'm going to do is take some brief testimony from both of you. We may be repeating actions that already happened, but just want to make sure in case we didn't, we'll make the record clear. Ms. Priestley, I'll start with you. Would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the whole truth and nothing but the truth?
I do.
And you can put your hand down. Is it accurate that you're asking the court to enter an order that would grant the parties joint legal and joint physical custody?
Yes.
And that parenting time, including holiday parenting time, would be as the parties agree. Is that correct?
It is.
Is it also correct that you are not seeking child support?
I am not.
And do you feel without the payment of child support, you can sufficiently meet the needs of the children?
Yes.
And is it accurate that you are not on any public assistance?
I am not.
And do you think this agreement is in the best interest of your children?
Yes, I do.
Thank you. Sir, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Sir, are you also asking the court to enter an order that would grant the parties joint legal and joint physical custody?
Yep.
Pairing time and holiday pairing time would be as the parties agree. Is that correct?
Yes, sir.
Is it also correct that you are not seeking any child support in this matter?
Yes, I'm not.
And it's also accurate that you don't receive any public assistance?
No, I do not.
And do you feel this agreement is in the best interest of the children?
Yes, sir, I do.
Thank you. Friend of the court, has there been any informational or any support recommendations in this matter?
There has not. I do have both parties' information, and I did receive, I'm not sure if she did submit the judgment, because the judgment was dropped off here this morning with a friend of the court.
Oh, I apologize for that. I went to the friend of the court, not the county clerk, for that. I can, because I do have a copy, I can turn that into the county clerk if I need to.
We're okay, right? Now, we're okay. The front of the court will review it, make sure the terms are accurate.
Okay.
I will indicate, though, that there should be an informational only support recommendation prepared given the parties' agreement. Any questions, Ms. Priestley?
Should I do the motion to opt out of the child support at this point?
I think that would be appropriate, yes. There's a form that you can get. Both of you sign it. There's an advice of rights that regarding the rights that you're giving up. So I think that would be appropriate, yes.
Okay, should I contact friend of the court for that paper, that document?
Yes.
Okay, thank you.
You're on.
Yes.
I'll reach out to the parties after the informational one is done, because the judgment will need to be updated with the provisions that they're indicating with the opt-out and some other things.
Okay.
So that will need to be updated as well.
Thank you. Any questions, Mr. Bell?
No, sir.
All right. Thank you both for appearing. You're all set for today.
Okay, thank you.
Thank you.
The court would next call the matter of Sarah Foster versus Vincent Barbagallo, file number 11-14246-DM. You have the parties on that matter present.
Yes.
It looks like it's Sarah Smith now. Is that correct, ma'am?
Yes, and I did file to change that. I did send in my marriage license and things, so it should be able to.
Unfortunately, the dockets don't always.
Oh, that's okay. No, I just
Get up.
That's fine.
Thank you. And sir, can you hear me okay?
Yeah, you're 5x5. This is Vincent. I'm here. Vincent Barbagallo. Can you hear me?
Yes.
Okay.
All right. And Ms. Foster, these are your motions, is that correct?
Yes.
And do the two of you have an agreement, or are you in disagreement?
No, we're in agreement.
Okay. Would you please raise your right hand? Ms. Smith, swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right. Can you please explain what your agreement is and what changes are being made?
Sure. Basically, we're reverting back to exactly how things were prior to Brianna moving up with Vince. We're going back to the $1,200 a month in child support. We will go back to joint legal custody, and I will have primary physical custody. And I have odd years of Christmas, even of Thanksgiving, and then he has the opposite, which is everything that we had prior. We're basically switching everything back because she's now back. She's going to now be back living with me.
Okay. And there's one other child that's remaining unchanged. Is that correct?
Yes, that's Owen. Yep, and everything is remaining the same. We've never changed anything with Owen.
All right. Do you feel this agreement and change is in the best interest of your child?
Yes, I do.
The details then on your filing that address holidays and that information, that is what you're agreeing to, is that correct?
Yes.
All right. Thank you. Mr. Barbagallo, could you please raise your right hand?
Mm-hmm. Yes.
And do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And sir, you heard what Ms. Smith has stated for the record. Is that your agreement also?
Absolutely.
Okay, so you guys would have joint legal custody. She would have the primary physical custody of Brianna. Is that correct?
That is correct.
And you're agreeing to pay $1,200 a month in support. Is that correct?
Yeah, across both, through Owen and Breeze.
Right, that's for both. I'm sorry.
Correct. Correct. $1,200 a month total.
Yes.
All right, and you heard the holiday and parenting time plan laid out, and you're in agreement with that also?
I am.
And you believe that is in the best interest of your daughter?
I do.
Given that information, then the court will order those changes to be made. Anything else, Ms. Smith?
No, that was all.
Okay, in front of the court.
With her motion, she indicated graduation date for.
Oh, that's right. Yes.
Okay, so ma'am, you're asking to extend support to graduation?
Well, yeah, if needed. So the hope is that Brianna will catch up, but if she can't, Vincent and I have agreed that we would extend it until either she's 19 and a half or until she graduates, because she did fall behind with her, with the school. So as of right now, she needs to take extra classes in order to catch up to her when her graduation date should be. If she's able to do that, then as soon as she graduates, then we would stop it or extend it to either the 19 and a half or her graduation, whichever would come first.
Okay. Mr. Barbagallo, are you in agreement with that?
Absolutely, yes.
All right, so then we would grant the post-majority support and extend the support. When is the anticipated graduation at this time?
Well, that's hard. So right now, if she was to graduate on time, it would be this not this summer, but the following. So that would be what, 2026, the summer of 2026. Otherwise, it would be 2027. It would be anywhere between halfway through that year up until summer, depending on how many classes she could get in. She's essentially about a year behind, but if she's able to take the classes, then she's able to maintain taking extra classes, then we can try it. We're trying to get her caught up. So
we typically put a date on there so that we've got that controlled. So what I would be inclined to do is maybe go with that end of the school year 2026 date. But if there is an issue, then you would have to address the court again, and we could extend it one more time.
Well, the 2026. Oh, okay. So the 2026 would be an extension already. Okay. Yes, that's fine. Sure. Yep. That's fine.
All right. So we'll say through, do they graduate in May or June?
They graduate in June. So it's usually mid-June.
Okay. So we'll say through June of 2026. And obviously if there is an issue, then that can be addressed. If you know that, when you know that in advance, if she's not graduating, then you can come back before the court to extend that.
Okay, that sounds great.
All right, any questions, ma'am?
No, thank you.
Sir, do you have any questions?
No, not at all. Thank you.
From the court, anything additional?
I don't believe so.
All right, thank you both for appearing. You are all set and you can sign off.
Okay, thank you.
Court next call the matter of Bethany Osborne versus Mark Osborne, file number 23-19403 EM. You have the parties on that matter present. All right, I see people that I think are here for this.
Yes, I'm here.
I'm present.
Thank you. So it looks like this was referred to me following a denied ex parte motion by Miss Osborne. Is that correct, ma'am?
Yes, it is.
Has that issue been resolved or not?
I believe that it's been mostly resolved from the original incident.
I do have a question, Your Honor. So there's a PPO that Bethany put out against me, and I was served back in November. I'm just curious if there's a possible way that we could get a court order for a third-party messaging service so I can get in contact with Bethany in regards to the children.
All right, well, let me first figure out where we're at. Were the two of you recently in front of Judge Hunter?
We go this afternoon, Your Honor.
This afternoon, okay. Is that hearing to address all issues or just financial issues, or does it address custody and support also?
No, it's just to address the divorce part of it and most of the financial stuff.
So you have an actual trial this afternoon?
Yes, sir.
So it looks like there was a custody order in August granting sole legal and sole physical to Miss Osborne. Hearing time every other weekend. So ma'am, are you looking to change that order at this time?
Not at this time. There was a time when the kids did not feel safe going to his house, and I was looking to change it. But like I said, I think him and at least the two younger children have resolved some of the issues.
Okay, and that's what led to your ex parte request?
Yeah. Was
All
after
right,
an
well,
incident at his house involving the police.
So you don't think we need to make any changes then at this time, is that correct?
No, sir.
Mr. Osborne, you were asking about, well, you're going to be in front of Judge Hunter this afternoon, so certainly I'm assuming he's going to give you the opportunity to make those requests.
Okay.
So given that we're here on the ex parte matter filed by Ms. Osborne, she indicates that is resolved, then the court would not schedule a further hearing on this issue. Obviously, if there's things that are not resolved after your trial, each of you would have the opportunity to file any potential new motions to address any issues. Any questions, ma'am?
No, sir.
Any questions, Mr. Osborne?
No, Your Honor.
All right, thank you both for being here today. You are all set and can sign off. We're next call the matter of Brittany Burris versus Tyler Nash, file number 15-15739DM. We have the parties on that matter present.
I'm here.
All right, both parties are present. Do either one of you have an attorney that's appearing for you today?
No, Your Honor.
Nope.
All right, thank you. So we were scheduled today to place an agreement on the record. Is that correct, Ms. Burris? You are the plaintiff, so is that correct?
Yes.
Okay, and is it simply adopting this mediation agreement that the court received?
Yep. And I believe you were supposed to receive one this morning, the updated version that we worked on last night.
Okay. I've got one dated Tuesday, February 11th. So that must be the updated one. Is that correct?
Yes, sir.
Okay. And sir, that is correct that you're asking the court to adopt this mediation agreement?
Yes, Your Honor.
All right, Ms. Burris, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And is it correct, ma'am, that you're asking the court to adopt the mediation agreement dated February 11th, 2025?
Yes.
That lays out some parenting time terms as well as holiday parenting time and other issues. Is that correct?
Yes.
And you believe this agreement is in the best interest of your children?
I do.
Thank you. Mr. Nash, would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And sir, are you also asking the court to adopt this mediation agreement dated Tuesday, February 11th, 2025?
Yes, Your Honor.
And do you believe this agreement is in the best interest of your children?
Yes, Your Honor.
Is there currently child support in this matter?
Yes.
Pay child support?
Yes,
Is there
Your
any
Honor.
request or need to change that support based on this new agreement?
I'd imagine that there would be a reevaluation sometime. I don't know when our last one was, but
And does this agreement change the number of overnights that you currently receive, sir?
yes.
Do you agree with that, Ms. Burris?
Yes.
Didn't see anything in the agreement itself regarding child support. So I would I would refer the matter then for a new child support review and recommendation based on the terms of the mediation. Any questions, Ms. Burris?
Nope.
Any questions, Mr. Nash?
No, Your Honor.
Front of the court, any questions?
Yes, Your Honor. I just want to clarify that there's not another mediation agreement that needs to be put on the record, that this one trumps the one that this hearing was originally set in place.
Okay. So this one dated February 11th, that's all the terms, is that correct?
Yes.
Yes.
All right. All right, thank you for that. You are all set and can sign off.
Thank
Thank you, Your Honor.
We would next call matter of Lauren Harding versus Casey Moore, file number 24-19808UI. We have the parties on that matter present.
Yes.
Yes.
All right, thank you. Both parties are present. I believe this is a friend of the court petition. Is that correct, friend of the court?
That's correct. We are requesting to change the suffix on this docket from UI to DS because Michigan is the state that's enforcing and establishing the support orders.
All right, any other issues to be addressed?
Yes, and then we also wanted to clarify the joint and physical custody. The judgment of support gives the plaintiff legal custody and then parties joint physical. But that contradicts what we see in the child support order that is prepared. As parties, one of the parties has 0 overnights, therefore if it's a joint physical, we would expect to see more overnights.
All right, thank you. Ms. Harding, you're the plaintiff, so I'll ask you, what is the agreement the two of you have as far as legal custody and physical custody?
At this point, Casey doesn't have any overnights. It just doesn't work for us financially for me to send my son down there or for him to come up here.
All right, so you've got the primary physical custody, is that correct?
Yes, that's correct.
Right. And it wasn't the intent for you to also have the sole legal custody?
Yes.
Okay. Mr. Moore, do you agree with that?
Yes, sir.
Okay. All right, so we would indicate then that that Ms. Harding has the legal and physical custody. Parenting time is as the parties agree. And we will change the case from a UI to a DS. That's kind of a formality. If you have any questions regarding that, you can let me know, but that is simply to reflect what the correct case heading in this matter should be. Any questions, Ms. Harding?
No.
Any questions, Mr. Moore?
No, sir.
All right, thank you both for being here today. You may sign off.
Thank you.